Good morning, everybody. Thank you for joining our Thursday town hall. We're going to give it a couple minutes and for the room to fill up, and we'll get going as quickly as we can. So have some patience. We'll be right there. Thanks. Good morning, everybody. Thanks for joining our town hall today. We're going to get started in about a minute or two. So we're just going to wait for the room to fill up, and we'll kick it off in just a minute. So thanks for waiting. All right, Nick, it looks like the room is pretty full. Do you want to kick it off?
Yeah, let's do this. Hello and good day. Thank you all for joining us today. We're hosting town halls every Thursday while we're all stuck at home in an effort to keep you informed, answer your questions, and to keep the community engaged. We firmly believe that ongoing and opening these lines of communication and collaboration will be key to developing during these challenging times. Our goal with these town halls are to provide a forum for cooperation, sharing best practices and ideas, as well as answering your questions. In addition, we have also launched the SIA Industry Hub on our website for the most up-to-date resources and tools, including financial resources. Go to snowsports.org/COVID hub. This page is updated daily, so please check back often. Today's town hall, the CARES Act. What's in the $2.2 trillion stimulus package for you, your employees, and your business? Is the third in our weekly town hall series, and we're excited about the group we've assembled today. Today's discussion will be led by our partners at Jones Waldo, a law firm based in Salt Lake City. Amongst the various areas of legal expertise they provide, they are currently assisting those in our community, both local and abroad, with the tough economic and legal challenges with which we are now presented. They are monitoring both health and legal developments as they emerge and are staying abreast of tools that are available to help both individuals and businesses emerge from this time with as little disruption as possible. With that, we're excited that we're sharing their expertise with us today. Today's presenters, Spencer Topham. Spencer Topham is a shareholder in the Jones Waldo Corporate Securities Practice Group. He focuses his practice on mergers and acquisitions, corporate formations and restructuring, and a variety of other commercial transactions, including technology licensing. Spencer is a trusted advisor to investors and businesses in a wide range of corporate matters and day-to-day operational issues. Gunnerson. Jeffrey Gunnerson is a tax attorney with Jones Waldo. He has extensive experience assisting business and executives with tax planning, resolving tax disputes, nonprofit formation and IRS qualifications, compensation, and employee benefits. Lastly, Bruce Babcock. Bruce is an immediate past chair of the business development at Jones Waldo. He has over 38 years of experience advising employers and executives regarding compensation, employee benefits, and tax planning. With that, let me hand it over to our friends from Jones Waldo.
Hey, good morning, everyone. This is Spencer Topham, or good afternoon, depending on where you're located. And I'm just going to be talking today on the Paycheck Protection Program, which I'm sure many of you are familiar with, have researched a little bit. I will preface this by saying that the information on this program is still changing to some extent. So, you know, there definitely will be some changes, and, you know, you want to with your counsel before you make any decisions. As we know, you know, several weeks ago, Congress passed the Coronavirus Aid, Relief, and Economic Security Act, which is the CARES Act, which allocated $350 billion to help small business kind of keep their workers employed. As of this morning, it looks like you know, that amount is going to be supplemented in some capacity, which is still kind of being debated in Congress, how much more is going to be added to that, just based on the you know, initial reaction to the program and the amount of loan applications that they saw. So the Paycheck Protection Program is detailed in Section 1102 of the Act, and, you know, under it, small businesses that qualify can obtain 100% federally guaranteed loans if they maintain their payrolls during the pandemic. The reason that many people are interested in these loans is because they can, you know, for some portion, if those payrolls are maintained, and you know, they keep the payrolls after the pandemic. The loans are offered by private lenders, so, you know, that's been some of the confusion that's been going on. Different lenders have been doing different things. The, you know, underwriting requirements and you know, some of that information hasn't been consistent from Treasury yet. So, you know, depending on your lender, they may require, you know, different documentation, or, you know, have a different interpretation of how things work. Hopefully, there's some more consistency in the next few weeks, but, you know, just anecdotally from what I've heard, people that have been going to lenders have been, you know, getting different answers to different questions depending on the lender. To be eligible, you know, this is administered by the SBA. So to be eligible, you know, the business has to have been in operation on February 15th, 2020, had employees for whom it paid salaries and payroll taxes. You know, I understand a number of you are independent contractors or sole proprietors. We'll get into that in a minute. And, you know, that means that the business has fewer than 500 employees, is a 501c3 with fewer than 500 employees. It's an independent contractor, operates as a sole proprietor, or it's an individual who's self-employed and carries on any trade or business. The SBA's affiliation rules do apply. There are some exceptions, but, you know, the affiliation rules basically, you know, I won't go too deep into those, but they look at, you know, majority and sometimes minority equity holders in a business, and, you know, or look at, you know, any other businesses that business may have an interest in, and they aggregate, in some cases, the employees of those other businesses together, so that, you know, to get to that 500 employee count. So, you know, if a business had 150 employees, but, you know, it had interests in another business that had 400 employees, then, you know, in that case, it probably wouldn't be eligible. There are some carve-outs for that, which are for, you know, food services. You know, they're only counting per location for restaurants, and, you know, businesses that operate as a franchise, on a franchise model, they're not going to aggregate for those purposes. You know, some of the lender requirements so far, you know, you need to show that the pandemic makes the loan request necessary to support ongoing operations. That's, you know, probably not a hard bar to overcome there. The business will use the loan proceeds to retain workers. The business doesn't have an application pending for a loan for a similar purpose. And, you know, from February 15th, 2020 to December 31, 2020, the business did not receive a loan for a similar purpose. Loan amounts, you know, the cap on the loans is $10 million. businesses that were operating, last year during this kind of period, this 8-week period, February 15th to June 30th, the maximum loan amount is equal to 2.5 times the business's average monthly payroll cost during that time period. For businesses that weren't operating between February 15th, 2019 and June 30th, 2019, the maximum loan amount is equal to 2.5 times the average monthly payroll costs between January 1, 2020 and February 29th, 2020. The definition of payroll costs, what's included in that, salary, wages, other compensation, payment of cash or tips, leave payments, vacation, medical, sick leave, severance benefits, payments for group health care, employee benefit plans, payment of retirement benefits, or, payment of state and local taxes that is assessed on employee compensation. For sole proprietors and independent contractors, payroll costs include the sum of payments of any compensation or income of a sole proprietor or independent contractor that's a wage, commission, income, or similar compensation that doesn't exceed $100,000 a year. And I have a little more on that a bit later. The amounts that are excluded from payroll costs are, any compensation to any individual employee, or, if you're an independent contractor, in excess of $100,000. And that's prorated for the period of June 15th, 2020 to June 30th, 2020. Payroll taxes and income taxes are excluded. Any compensation of an employee whose principal residence is outside of the United States. And then qualified sick and family leave, for which credit is allowed under the Family First Coronavirus Response Act, which, many of you are familiar with. That modified the FMLA to some extent and gives employers a credit on payroll taxes for, certain leave payments, and paid time off that they're paying employees during this time. The forgivable amount of the loan, a business that receives these loans is going to be eligible for loan forgiveness equal to the amount spent on the following items during an 8-week period that begins on the origination date of the loan under the program. So the date your loan is originated, my understanding is that starts the 8-week clock ticking for you to, have your payroll and substantiate that, compared to last year for loan forgivenesses. So payroll costs are included, mortgage interest, for any mortgages that are incurred in the ordinary course of business, rent, and utilities. However, the amount, they've clarified that, about 75% of that amount needs to be for payroll and 25% can be for these other items. The more you go up on the other items and down on payroll, the less likely you are to get forgiveness on that portion of the loan. The loan forgiveness can be reduced if there's a reduction in the number of employees or a reduction greater than 25% of wages paid to employees. So, this little equation that's on the slide here kind of shows how that works, and there's several different options here for, what you're using for the denominator. But, you have the payroll costs that you've calculated, as we discussed above. And then you multiply that by the average number of full-time equivalent for the 8-week period on the date of loan origination. And then you would divide that by, the average number that you had last year during that same period of time. Or, if you weren't operating last year during that time, the average that you had January 1 to February 20th. And then, you could also have a reduction based on wages, as shown here. You have your payroll costs, and then, you would subtract, for any employee, during the 2019 pay period, at an annualized rate of $100,000. If there was any reduction that's greater than 25%, that would get subtracted there from the forgiveness. So, I mean, for example, on the reduction in the number of employees, if a business had 20 employees during the 2019 period and only maintained 4 employees, and, payroll costs during that 8-week period in 2020 were $100,000, under this, first equation here, the business would multiply that by the payroll costs. So, that's $100,000 times 4, which is your, number of full-time equivalent employees. So $400,000, and then that would be divided by the number of employees under either of these options. So if we were doing the first option, we had 20 employees last year, 400,000 divided by 20, which would, come up with about a $20,000 reduction. So that's kind of how that works. Again, they're still tweaking this a little bit on the forgiveness side and finalizing some things. So it could change, but that's the basic concept. And that's probably all I have right now. So I will hand, and I'm sure you guys will have some questions that we can go over during the question and answer session.
All right. Everyone hear me? Sorry, I had trouble unmuting my microphone. Thanks, Spencer. So my name is Geoff Gunnerson. My portion of the presentation will cover a few different things. First, the Coronavirus Economic Stabilization Act of 2020, which is a portion of the CARES Act. Then we'll talk about a few other employer-related benefits under the CARES Act and some implications for retirement plans, employer-sponsored retirement plans. First, with respect to the Coronavirus Economic Stabilization Act of 2020. So the CARES Act really established 2 primary loan programs, the first of which Spencer's talked to us about, the Paycheck Protection Program, which is part of the Keeping American Workers Paid and Employed Act. And the second part of that, or the second primary loan provision under the Act, is under this Coronavirus Economic Stabilization Act. Under the Act, $500 billion was set aside for the U.S. Treasury's Exchange Stabilization Fund. The purpose of that is to provide loans, loan guarantees, and other investments to support eligible businesses, states, and municipalities, throughout this economic difficulty. Now, the primary difference between the loan program under the Coronavirus Economic Stabilization Act of 2020 and the Paycheck Protection Program is that under this plan or this loan program, there is no loan forgiveness, unlike with the Paycheck Protection Program. The funds, the U.S. Treasury has until December 31st, 2020 to deploy this capital. Under this loan program, there's actually 2 parts to this loan program. There's direct lending to specified industries, which I'll cover shortly, and then there's also direct lending to unspecified industries, we'll call them, which is basically everyone not in a specified industry. Now, the loans themselves, the rates at which these loans will be made is going to be determined by the Secretary of Treasury, accounting for the risk and current average yield on outstanding U.S. debt of comparable maturity. Note that terms of loans shall not be longer than 5 years under this program. Again, the principal amount of any loan under this program is not eligible for forgiveness. The Secretary has been directed under the Act, the CARES Act, to establish procedures for the application as soon as practicable. We expect that any day. They were to have released some within 10 days after enactment. So we're looking forward to more guidance there from the Treasury. Eligible businesses for this loan program include any U.S. business that has not otherwise received adequate economic relief in the form of loans or loan guarantees provided under the CARES Act. So generally, most all U.S. businesses should be eligible if they haven't received adequate economic relief otherwise. The losses that are covered for an eligible business include losses incurred both directly and indirectly as a result of the coronavirus. We don't have specific guidelines yet as to what that means exactly. That's to be determined by the Secretary, so we're awaiting further details there. The direct lending to specified industries, as you can see from the slide, up to $64 billion of the $500 billion is allocated to specified industries. These specified industries include passenger air carriers, air cargo carriers, and national security businesses. To qualify for a piece of that $64 billion, there's specific criteria that you must meet, but the credit generally must not otherwise be reasonably available to the borrower. Short of getting into all the details for specified industries, because it's such a narrow area, we're going to talk more specifically about the unspecified industries. As you can see on the current slide, the direct lending to unspecified industries includes $454 billion plus. The plus is any unused amount of the direct lending tranche to specified industries. So if there is anything left over from the $64 billion that goes unused, it'll be included as part of the $454 billion plus to the unspecified industries. The conditions of the direct lending to unspecified industries generally during the term of the loan, which again can be up to a 5-year loan, and for 12 months following the date upon which the loan is no longer outstanding. So for 12 months after it's paid off, the borrower is disallowed from buying back any equity securities listed on a national securities exchange, and this includes any parent company of the borrower. These type of buybacks are expressly prohibited, other than to the extent that they are required under a previously existing obligation that existed prior to the loan being taken. Another condition for the loan is that dividends and other capital distributions are prohibited during the term of the loan and for that 1-year period following paying off of the loan. Now, the Secretary does have some discretion, the Secretary of the Treasury has some discretion to waive either of these two requirements if it is determined that such waiver is necessary to protect the interests of the federal government. The conditions of direct lending also include, and this includes both the direct lending for unspecified and specified businesses, and this is a compensation limitation. So during the term of a direct loan in the 12 months following the date upon which the loan is no longer outstanding, no non-union officer or employee of the borrower whose total 2019 compensation exceeded $425,000 can receive an increase in compensation during any 12 consecutive month period, or receive severance pay or other termination benefits which exceed twice the individual's 2019 compensation. The additional $3 million compensation limitation is that no officer or employee of the borrower whose 2019 compensation exceeded $3 million may receive during any 12 consecutive month period total compensation in excess of the sum of $3 million and 50% of the excess of such officer or employee's compensation over $3 million. So for example, if there was an executive that received $4 million of compensation in 2019, in order to qualify for the plan, the same individual's compensation could not exceed $3.5 million, the $3 million plus 50% of the million over $3 million going forward for the term of the loan again and for 12 months following. Now, there's additional assistance for mid-sized businesses under the program. here the secretary is required to endeavor to seek and implement programs or facilities to provide financing to banks and other lenders to eligible businesses. Here, mid-sized businesses are defined as between 500 and 10,000 employees. Some of the limitations here are that these particular loans for mid-sized businesses, the interest rate on the financing is can be no higher than 2% per year, and payments may be deferred, both principal and interest, for the first 6 months of the loan. Now, it is required, of course, in order to qualify under assistance for a mid-sized business, that the borrower make certain certifications. As you can see from the slide, the loan must be necessary to support the ongoing operations of the borrower, which shouldn't be too difficult to show. The funds that are received must be used to retain at least 90% of the borrower's workforce at full compensation and benefits until at least September 30th this year, 2020. Further, the borrower must intend to restore not less than 90% of its February 1st, 2020 workforce and restore all compensation and benefits within 4 months of the declaration of the termination of the COVID-19 crisis. The business, similar to the prior requirement generally, but for mid-sized businesses, it must also be domiciled and created or organized in the United States, and must have significant operations in and a majority of its employees based in the United States. The borrower must not currently be in bankruptcy. Similar to what we've discussed previously, no dividends may be paid with respect to the borrower's common stock. The borrower must not outsource or offshore any jobs during the term of the loan and 12 months following. And the borrower must not abrogate existing collective bargaining agreements and must remain neutral in any union organizing efforts for the term of the loan. Of note is that there's a specific eligibility or conflicts of interest provision under this loan program. And basically what that says is that notwithstanding all the other conditions and requirements that we've noted here, certain businesses will not be eligible to participate in the assistance of the program if there's the potential for a conflict of interest. Specifically what they're talking about here with respect to conflict of interest is the principal executive officer and the principal financial officer of a business seeking to participate in the program must certify that the business is eligible, including that no covered individual holds, directly or indirectly, 20% or more of any class of equity interest in the business. And by class of equity interest, that includes profit interest, warrants, or other rights to purchase or sell shares. Now, who's a covered individual? Covered individuals under this program include the president and the vice president of the United States and the head of an executive department or a member of Congress, and further include the spouse, child, son-in-law, or daughter-in-law of any one of those individuals. So you need to be able to certify under this program that they do not have any interest in your business. And for the purpose of the 20% requirement, note that if there are multiple members that would otherwise be covered individuals, they will be aggregated to determine whether the 20% threshold has been crossed. So effectively, that's the loan program under the Coronavirus Economic Stabilization Act of 2020. Let me just quickly talk about a few other benefits and considerations under the CARES Act for employers. First, there's a provision to delay the deadline regarding contributions to retirement plans and health savings accounts. So this specific provision is not technically part of the CARES Act. The Internal Revenue Service under IRS Notice 2020-18 extended the deadline for making contributions to an IRA or for an employer to make contributions to its workplace-based retirement plan on account of the 2019 tax year. And that date has now been extended to July 15th, 2020 for those contributions. In addition, participants in a health savings account or Archer MSA for 2019 may make contributions for 2019 up to July 15th, 2020 in an effort to reduce tax liability and increase cash flow. The second item here, delay of payment of employer payroll taxes. This provision allows employers and self-employed individuals to defer payment of the employer's share of Social Security tax that they would otherwise are responsible for paying to the federal government with respect to their employees. Generally, employers are responsible, as you may know, for paying the 6.2% Social Security tax on employee wages. This particular provision requires that the deferred employment tax be paid over the following 2 years, with half the amount required to be paid by December 31st, 2021, and the other half by December 31st, 2022. The third item here, net operating loss rules and the modification for businesses. Now, this provision relaxes the limitation on a company's use of losses. Net operating losses are currently subject to a taxable income limitation, and they cannot be carried back to reduce income in a prior tax year. However, this provision provides that a net operating loss arising in a tax year beginning in either 2018, 2019, or 2020 can be carried back 5 years. This provision also temporarily removes the taxable income limitation to allow net operating losses to fully offset income. So these changes are expected to allow businesses to utilize the losses and amend prior year tax returns, which theoretically should provide critical cash flow and liquidity during this COVID-19 crisis or emergency. The next item, limitation on losses for taxpayers other than corporations. So this would apply to pass-through businesses such as partnerships, sole proprietorships, single-member limited liability companies, for example. So this provision modifies the loss limitation applicable to these pass-through businesses and sole proprietors so that they can utilize excess business losses and access critical cash flow, again, to maintain operations and payroll for their employees. Corporate AMT credits. The next item, the corporate AMT was repealed as part of the Tax Cut and Jobs Act, but corporate AMT credits were made available as refundable credits over several years, ending in 2021. This provision accelerates the ability for companies to recover those AMT credits, which allows companies to claim a refund now and obtain additional cash flow now. Interest deductions, the provision here increases the amount of interest expense that businesses are allowed to deduct on their tax returns. It increases that number from the 30% limitation to 50% of taxable income, with certain adjustments for 2019 and 2020. Immediate expensing of qualified improvement property. This provision is intended to enable businesses, especially in the hospitality industry, to write off immediate costs associated with improving facilities instead of having to depreciate those improvements over a 39-year life of the building, for example. The provision actually corrects an error in the Tax Cut and Jobs Act and increases companies' access to cash flow now by allowing them to amend a prior year return. Finally, on this slide, federal excise taxes regarding hand sanitizer. If any of you are in the business of producing distilled spirits, this provision waives the federal excise tax on any distilled spirits used for or contained in hand sanitizer that is produced and distributed in a manner consistent with guidance issued by the FDA, and it's effective for calendar year 2020 only. Now kind of changing gears a little bit and moving into employer-sponsored retirement plans. The CARES Act has put in some provisions to help provide relief to employees through their retirement plans. The first provision here is a coronavirus-related distribution. So what this allows is under this new distribution provision, current employees would be eligible to withdraw up to $100,000 for a coronavirus-related event. what that means is, or let me specifically talk about the limitation, because there is a little bit or something we need to be aware of. The plan itself will not be treated as violating any requirement of the Internal Revenue Code merely because a plan treats a distribution as a coronavirus-related distribution unless, and here's the key, unless the aggregate amount of the distributions from all plans maintained by the employer to an individual exceeds $100,000. So to the extent you have more than one retirement plan maintained at the employer level, the aggregate amount that may be withdrawn across all plans by that employer for any specific individual is $100,000. And now, generally, this distribution rule is applicable for 401k plans, 403b, IRAs, your most common type of employer-sponsored defined contribution and defined benefit plans. So what is a coronavirus-related distribution? Well, a coronavirus-related distribution is a distribution that's made on or after January 1st of this year and before December 31st of this year, and to an individual that's been diagnosed with the virus SARS-CoV-2 or with COVID-19 by a test approved by the CDC, or an individual whose spouse or dependent is diagnosed with such virus or disease by such a test, or by an individual who experiences adverse financial consequences as a result of being quarantined, being furloughed or laid off, being unable to work due to lack of child care, closing or reducing hours, or house of business owned or operated by an individual, or other factors that the Treasury will be putting forth. But those are the general factors. So if an individual has experienced either a positive test for themselves or their spouse, then they're generally eligible. Now, the certification process is interesting. An eligible retirement plan may rely on the employee's certification that they meet one of these requirements. So it's not up to the employer or the plan to verify it, but the employee itself to verify that they are eligible. With these type of distributions, there's no what we would normally call an early withdrawal penalty for individuals that are under age 59 and a half. That's the additional 10% tax penalty that you see with withdrawals for individuals under age 59 and a half. That has been waived. And unless otherwise elected by the taxpayer, the distribution of those funds, while they are taxable and includable in the individual's income tax or gross income, they'll be included over a 3-year period so as not to cause too heavy of a tax burden in any one year. But that again can be elected by the individual. Repayment of the distribution is not required, but it is optional. The individual receiving the distribution can elect at any time during the 3-year period beginning on the date after the date on which the distribution was received to make one or more payments or contributions in an aggregate amount not to exceed the amount of the distribution into an eligible retirement plan. So it can be replayed and put back in the retirement plan and then later used for retirement. If that is done, of course, it's treated similar to a rollover contribution from plan to plan rollover, and so then it eliminates the tax liability to the extent that the amount is repaid. Finally, with respect to distributions, for employer-sponsored retirement plans to offer this as an option in their plan, they're going to need to amend their retirement plan generally. But before that amendment takes place, the plan must be operated consistent with these rules and consistent with the idea that that's what they're going to offer. So the amendment itself does not have to take place immediately, although communications to participants in the plan would need to be made, but the amendment itself must be made by the last day of the plan year beginning in 2022, which would be December 31st, 2022 for plans that use a calendar year. Now, the other provision for retirement plans is the coronavirus-related loans. And let me note here that both these loan provisions and the distribution provisions are optional. Plans do not need, or they're not required to adopt these, but they can make these available to their participants. To qualify for coronavirus-related loans, it's effectively the same requirements for eligibility that we had for the distribution. These loans are available for a 180-day period beginning on the date of enactment of the Act, which was March 27th, 2020. So these loans need to be taken within 180 days after March 27th. What this provision does is change the loan limits. Historically, or prior to this, the maximum loan from a retirement plan was $50,000 or 100% of the present value of the vested benefit under the plan, which, you know, the lesser of those two. So the maximum loan amount that could be taken previously would be $50,000. This provision allows that number to be pushed to $100,000. Loans can be up to $100,000, and allows 100% of the employee's vested benefit in their retirement plan to be used for that loan. Now, repayments on outstanding loans can be delayed. In fact, repayment of any outstanding plan loans between March 27th and December 31st of this year, 2020, are to be delayed. So those payments should be delayed if you're adopting this provision. Again, the plan, just like with the distribution option, the plan must be operated consistent with this provision if you're going to add it to your plan, even before the actual amendment to the plan is made. And again, the same timeline is in effect for the amendment. The plan must be amended by the last day of the plan year beginning in 2022. And finally, with regard to retirement plans, there is a temporary waiver of required minimum distributions under all plans. No plan amendment is required for this. This is automatic. And this waiver provides that the requirement to receive a required minimum distribution from a retirement plan like a 401k is waived, is generally waived. But note that this provision under the CARES Act does not impact the provision of the recently enacted SECURE Act, which increased the age at which required minimum distributions must begin. It increased it to age 72. And so that, in somewhat of a nutshell, are the provisions for retirement, employer-sponsored retirement plans. Again, the distribution and loan provisions are optional. And if you're going to implement those for your plan, you need to make an amendment by the last day of the plan year beginning in 2022. And now I'll turn the time over to Bruce for implications on health and welfare plans.
Thank you, Geoff. So this is Bruce Babcock. I will be taking a few moments to address the impact of the CARES Act on health and welfare plans. As you probably know, the Families First Coronavirus Response Act, we'll call it the FFCRA, requires group health plans and health insurers to cover COVID-19 diagnostic testing without charge to the covered person. The CARES Act expands or clarifies that to provide that all diagnostic testing, without regard to whether the testing is FDA approved, must be covered. There is no special provision in either of these legislative acts that regulates coverage for treatment. It's only diagnostic testing that is required to be covered. If the enrollee or the covered person receives diagnostic testing out of network, the group health plan or the insurer will pay the provider at the negotiated rate, or if they don't have a negotiated rate with the provider, they're to use a cash price for that service that the provider is to have listed on their public website. So the intent is to generate some kind of transparency for costs when someone is going out of network. Group health plans, as you're aware, vaccines and other procedures are being fast-tracked. So group health plans insurers will be required to cover, again without cost sharing, any qualifying coronavirus preventive service, including vaccines, beginning within 15 days after the service has received federal government approval. So moving on, I'm going to speak about HSAs, in that in order for a high deductible health plan to be eligible to be paired with a health savings account, or HSA, the plan can only provide certain preventive care benefits, which would include annual physical examinations, routine natal and prenatal and child care, before the enrollee has met the deductible. So the CARES Act expands the list of eligible pre-deductible expenses that can be incurred prior to satisfying the deductible and covered. And those additional expenses include the testing and treatment of COVID-19. In addition, even if they happen to be using telehealth services. So this allows more high deductible health plans to retain their HSA eligible status and provide COVID-19 coverage. For many years, the tax code has allowed employers to establish educational assistance programs, and these programs permit the reimbursement or payment for the employees' qualifying educational expenses, including tuition, books, and school fees up to a maximum amount of $5,250 per year. The CARES Act adds student loans to that list for 2020. So for 2020 only, student loans can be repaid up to that $5,250 amount, taking into account other reimbursed educational expenses. The tax code is also amended by the CARES Act to provide that beginning January 1 of 2020, retroactively, over-the-counter medicines and drugs, along with menstrual care products, are considered medical expenses, which can be reimbursed with pre-tax dollars from health savings accounts, HSAs, healthcare flexible spending accounts, that's Section 125 plans, and Archer MSAs. The FFCRA requires employers with less than 500 employees to provide employees with paid leave and expanded MFLA benefits, but it also provides, as was mentioned earlier, a dollar-for-dollar tax credit against Social Security taxes to enable the employers to pay for those leaves. The CARES Act provides another and separate tax credit, which is called the Employee Retention Credit. This credit is not dollar for dollar, but it's equal to 50% of qualified wages and allocable health plan expenses in an amount up to $10,000 per employee. To the extent those wages and expenses are incurred between March 13 of 2020 and December 31 of 2020. In order to be eligible for this employee retention credit, the employer must have either fully or partially suspended its operations during a calendar quarter due to a government-imposed coronavirus-related restrictions, or experienced a decline of more than 50% of its gross receipts in a 2020 calendar quarter compared to the same quarter in 2019. Once, if the employer has incurred a significant decline, that decline continues to be considered significant and qualifying for the credit until the first calendar quarter following the calendar quarter for which the gross receipts exceed 80% of the gross receipts for the same quarter in 2019. Importantly, this employee retention credit is not available to employers who take out a Paycheck Protection Program loan from the SBA. So what are qualified wages for purpose of calculating the credit? For employers with fewer than 100 full-time employees in 2019, all employee wages are qualified wages, whether the employee is open for business or subject to shutdown order. Even if the employee's work time are paid for full-time work, the employer may still claim the credit, unlike the credit under the FFCRA. For larger employers, however, qualified wages are only those payments made to employees who are furloughed. That is, they are not actively providing services, and that they're furloughed and not providing services due to a full or partial shutdown order or because of the 50% decline in gross receipts. Note that the employer is not required to pay wages that qualify for this credit, but if they do pay the wages, they can claim the credit. There's no double dipping permitted. Employers cannot claim the employee retention credit on the same wages that they paid for sick leave or extended leave under the FFCRA on which they claimed a credit. So with that, we'll turn it back to others for answering questions. Thank you.
Well, thanks everybody. If you have any questions, just please feel free to type them into the Q&A bar, which is located at the bottom of your screen, and we'll get to as many as we possibly can in the time we have left. Spencer or Bruce or Geoff, feel free to jump in. I know, Spencer, you've been answering some online, but please feel free to answer any verbally if you'd like.
This is Bruce, and I'm curious to know what Spencer has said in response to a prior question as a follow-up question involving foreign employees of the group for purposes of the affiliation rules. And I will chime in, and Spencer, you can correct me if I'm off base. But my understanding is that the SBA affiliation rules under the regulations and in past practice would say that if a foreign affiliate is affiliated under affiliation rules, you would have to count the employees for purposes of determining whether or not you have more than 500 employees. However, the interim final rules say that they look only at the number of employees that are residents who have a principal residence in the United States. So if you have a foreign affiliate that's affiliated with the borrower, you wouldn't count those employees, even though they're affiliate, if they don't have a principal residence in the United States. That's my understanding.
Yeah, Bruce, I've been looking at this issue. Someone asked a question on that, and I think there is still some confusion on this because, yeah, the regular affiliate rules would say that you need to count them, but, you know, the way that this has been drafted, it would seem like you don't. So I think they're still waiting for some clarification from SBA on that issue.
That would certainly help because the interim final rule is contrary and contradicts with the regulation.
Yep, that's the issue.
Hey, Spencer, it seems as though Wendy Carey's got a question in the Q&A box.
Yes, that looks like something there for Geoff probably, which is why I haven't answered that one yet. I've been trying to answer everyone else here.
Yeah, Wendy Carey asks, do SEP IRAs qualify as employer-sponsored retirement plans for inclusion in the forgivable part of the PPP loan, even if not paid until July, or do we need to pay within 8 weeks of loan origination? I'm a little, I guess, confused about the question as far as SEP IRAs qualifying for employer-sponsored retirement plans under the PPP loan provisions. Spencer, do you have any insight given the PPP loan piece of that question?
I don't. I mean, my understanding is that it's 8 weeks from origination. I don't know, if that changes in that context. I wouldn't think it does, but I haven't looked at that in the retirement plan context.
Right.
There's another question that I want to throw out to you guys. It says, for a subsidiary 100% owned by a foreign parent, are foreign employees of the group included in the number of employees under the SBA affiliation rules?
That's kind of what we were just discussing between Bruce and I, and we've had multiple questions on that from people, and the answer is we don't know currently, because there's a conflict between the SBA general affiliation rules and the interim final rule on that.
Okay, great.
But it, to me, Spencer, they could certainly apply on the basis of the interim rule and see where it takes them.
Yeah, that was kind of what I told someone else on the Q&A is, worst case, I guess you get rejected. Otherwise, it probably makes sense to get in the queue, just based on, the extreme interest that this program is giving off. So.
There was another question from one of the guests. It says, does the Colorado stay-at-home order qualify Colorado businesses for the employer retention credit, even if gross receipts do not decline by 50%?
Okay, that would be a question for me. I'm not sure exactly what the Colorado stay-at-home order does, but it would appear, based on its face, my reaction is it would qualify, even if they don't have a significant decline of their gross receipts. Because it's an either-or test, a fully or partially suspended operations due to government order. So my thinking is, but you want to confirm that with probably Colorado Council, that it would qualify.
Okay. Here's another one. If we apply with 5 FTEs and a loan was provided, does it matter who are rehired to meet the 5 FTE to compare it to the previous year period? As an example, if only 3 of the 5 were available to rehire, could we rehire 2 new or old employees? Spencer, did you hear that one?
Yeah, sorry, one second. I'm just looking at that. I've been answering some other questions on here.
Okay. Or maybe Bruce or Geoff. Do you want me to restate the question, you guys?
Yeah, if you could.
Sure, no problem. The attendee asks, if we applied with 5 FTEs and a loan was provided, does it matter who are rehired to meet the 5 FTE to compare to the previous year period? As an example, if only 3 of the 5 were available to rehire, could we hire 2 new or old employees?
Yeah, I think you're just comparing, my understanding under the rules right now is you're just comparing number of FTEs last year, if you were operating to number of FTEs this year. I don't think they have to be the exact same employees. I think, we're just trying to basically just, the policy goal was to, try to keep payrolls, consistent. So, it doesn't mean you have to go hire the exact same people that you had last year, if that's the question.
Yep, that seems like it is. Thank you. Next question. Do you have to have your 2019 taxes done before one can apply?
No, I don't think you do. And there is some discussion about that. If you are an independent contractor and you don't have 2019 taxes, you will, have to substantiate probably provide, an income statement, that type of thing to kind of show net income. But again, we're kind of still waiting for this independent contractor application. So, some of that may be clarified in that application. Hopefully that comes out today. I'm assuming that's a question from an independent contractor, but I think even in the small business sense, I don't think you necessarily have to have completed your 2019 taxes. Geoff, I don't know if you have any comments on that.
I don't have anything more. Presumably, we're talking about the PPP loan program, but I don't know anything further than what you've stated.
Here's a question for from Doug Hopkins. Our U.S. corporation is wholly owned by an Austrian corporation. My reading is that we don't qualify for PPP at all, regardless of the number of employees. Just want to get your perspective on that.
Yeah, Bruce, do you have any thoughts on that? If it's a wholly owned subsidiary.
My reaction, I'm not aware of any prohibition on having a foreign owner of a U.S. corporation that's applying for a PPP loan. I think it's the same answer to the prior one about whether counting employees of foreign affiliates. So I don't know why a wholly owned U.S. corporation, wholly owned by a foreign parent, would be precluded from applying if they meet the other requirements, including the 500 employee maximum.
Okay. Just a couple more questions. One from Jason Hume. I applied for the EIDL and PPP. Is it okay, or does applying for one disqualify me from the other?
It doesn't disqualify you, but the $10,000 grant, I believe, under the EIDL will be, reduced out of your loan forgiveness on the PPP.
Great, thank you. One last question that I see now. Could all of the loan proceeds be used for payroll purposes, or can it only be 75%?
Sure, yeah, you can use it all for payroll purposes. It's, that 75-25 is just, kind of the Congress trying to make it so that, you don't get this payroll loan and, use the majority of it on, the other items, which if you maintain, just the same employees that you had last year, but had a low payroll and then just, got a larger loan and used it for, rent and things like that. So, yes, you can use, the entire loan on payroll, and, that's kind of the policy behind it.
Great. There's one last question, and then I'll hand it over to Nick. From Todd Gardner. We have had our PPP loan funded. We have 5 restaurants that are currently closed. Do we have to hire back 75% of our full-time employees during the 8 weeks by June 30th, 2020? The loan forgiveness information is not very clear. Also, does that include FTEs?
Sorry, can you repeat that one more time? I'm not seeing that on the.
Sure, it's actually over in the chat room.
Sorry, I haven't been in the chat room. I've probably missed a lot over there.
No, it's okay. I'm bouncing back and forth. This is one from Todd Gardner, and it says, we have our PPP loan funded. We have 5 restaurants that are currently closed. Do we have to hire back 75% of our full-time employees during the 8 weeks or by June 30th, 2020? The loan forgiveness information is not very clear. And also, does that include full-time equivalents?
My understanding is that, for the purpose of forgiveness, the 8-week period begins on the date of origination. So what they're going to be comparing for forgiveness, so, say he gets a $500,000 loan, the measurement period is from the date of the loan origination through that 8 weeks. What was your payroll during that time period compared to your payroll last year, or earlier this year, if you want to use that option under the formula. But that's kind of my current understanding with what's out there on what you'd be doing. So I would say if the loan has already been originated, then, yes, if you want to take advantage of the full forgiveness, you should have your payroll, back up to what it was last year at this time for the 8 weeks.
Great. One more question from Bob Olson. What determines FTE is weekly hours 20, 30, 32, 35, or 40 worked from 1-1 to, January 1st to 2/29/2020? Spencer, can you see that question? It's a little bit easier to read than.
Yeah, let me.
It's in the chat room.
You see there? Is that in the chat room? Okay.
Yeah.
Sorry, let me get over there.
It's about fourth from the bottom.
Yeah, I can see that. So, yeah, 1 second. I mean, for FTEs, it's not just FTEs. I mean, it's all employees that you have. I think, sorry for eligibility, but if we're talking about forgiveness specifically, I can get back to him on that, but I think it's just kind of the general definition that you have kind of under some of the employment laws for full-time equivalents. So yeah, I'd probably have to follow up on that.
Okay, great.
Okay. Well, I want to thank everyone for today, and specifically Bruce, Spencer, and Geoff. And thank you all for joining the call. We hope you found it beneficial. I know it's a lot to comprehend, but it is very important. If you have any additional questions, please feel free to email us at info@snowsports.org, and we will be in touch immediately. And please don't forget to visit our COVID Industry Hub for all the resources you need. And most specifically, a recording of today's discussion will be posted there shortly, in case you want to re-listen to it at a later date. You can also find it at snowsports.org/COVID hub. Next week's town hall will be a discussion around recreating responsibly during the pandemic and SIA's hashtag Curb Your Turns initiative. Our guests will include Megan Michelson, writer, editor, and she'll be our moderator. Sarah Carpenter, co-owner of American Avalanche Institute. Jay Miller, physician assistant certified at Cedar Point Health in Montrose, Colorado. And Mark Schroetel, general manager of Powder Mountain Ski Resort. This will be a very important discussion, so I hope you'll all join us. We'll be sending out our registration link soon. I and my staff are here for you during this tough time. Please lean on us. This is why we're here. We'll get through this and become stronger because of it. Once again, thank you very much. Stay healthy and have a great day.